Good morning. Be seated, please. All right, we'll start our next case, Atlantica 1 versus ADRAGNA. Whenever you're ready, counsel.
May it please the court, Mr. Ward. Your Honor, my name's Larry Griggs. I'm the attorney for the appellants, and I was the attorney at the trial below. There are three primary issues on appeal. First is an erroneous jury instruction where the court drafted the Tord and Johnson versus Davis into a breach of contract case. The second point is where an expert witness was allowed to be a conduit for hearsay evidence. And the third was when I was not allowed to introduce evidence by way of cross-examination of the defendants in this case. Do any of you have any questions for me?
We will as you go along.
Okay, thank you.
Let me just ask in reverse order on the IRS thing.
Yes.
I mean, from a standpoint of the trial in this case, which was, did they breach their contract by failing to disclose something that they should have?
Correct.
Why does it make any difference whether they're house flippers or not, or whether there was a tax benefit to them to stay in the house for 2 years? Or, I mean, how does that tend to prove or disprove that they were obliged to disclose a fact to you?
Right, that's why I have that as the third issue. It's probably the least probative of the three.
Right, and that's why I just wanted to dispose of it quickly.
No, but I'll answer that. The reason is their defense was, in fact, the first thing they said is this was their dream home. Why would anyone live in a house for 3 years if it was defective? So, and you may recall initially when Ms. ADRAGNA took the stand, she said they'd only lived in this one house in St. Augustine, and it was on cross-examination that I actually drew out that not only had they lived in a prior house, they'd owned a condominium, they'd built an apartment complex, her husband was a licensed real estate broker. Also, she testified in response during direct examination that after she found out she was sick, they put the house on the market for sale, whereas on direct cross-examination, I elicited admissions from her that in fact they had listed it for sale before. Her husband had tried to sell it, and they had listed it with, I believe it was Executive Realty before. So when they said this was their dream home, and they only sold the home because she was sick and didn't have any support in St. Augustine and wanted to go back to New York, I'm entitled to bring out on cross-examination, well, not only did you list it for sale before you were aware of this illness.
Well, but you brought all that out, didn't you?
I did do that, but I didn't.
Isn't your point on appeal just
right,
that you couldn't introduce the IRS code?
Exactly.
To show that there was a tax benefit to staying in the house long enough to get the exclusion?
Exactly. And, you know, the important part of that is to understand what the legal standard is, and if I may.
Well, I don't want to waste all your time. I mean,
okay, let me just say this. There was no reason to keep it out. What was the ground? Why was I not allowed?
Doesn't this case really turn on the main issue, which was, did the jury instruction get it wrong? I mean, at the end of the day, if you compare the jury instruction to what their contractual duty was to disclose, how does it vary? What were they required to disclose that you thought they knew and didn't know?
Well, let's talk about that, and I'm glad you did it. And I have to say, I was glad to see Judge Palmer's on the panel, because I know he was on the Burlington and Rockenbach case, which dealt with how do you determine if there's a breach of contract. That's principally where I got into it with the judge. And I know I probably used some colorful language. You know, you talk about a dry record. What I'd like you to know was I was begging and pleading with the judge. Please, please, please. Now, this is what their interpretation is by the judge. He applied Johnson versus Davis was a tort. Now, first, we need to understand, in Johnson versus Davis, page 627, there was no contractual obligation of disclosure. Okay, there's no place for Johnson versus Davis. In fact, I joked with the judge, if I had a son, I'd name him Johnson Davis Griggs.
But my point is, doesn't the contract that was utilized here incorporate the standard that is in Johnson v. Davis?
See, and that's a very good question. Actually, no, okay?
Well, how does it differ?
Well, you have to read the contract. As the court said in Burlington and Rockenbach, in order to determine if there's a breach of contract, you have to read the contract. In this case, my clients contracted by a house for almost $1 million. Obviously, the condition of the house is material. Second, my clients had a 10-day right of inspection. If you look at the contract said, which is part of the appendix, the contract stated, Your Honor, that my clients could, that the entire contract was subject to, and this is page 24 of the appendix, quote, subject to buyer's approval and acceptance of a professional home inspection. There's no dollar amount there. It doesn't say it's subject to approval and acceptance of a home inspection showing a defect that materially affected the value of the property.
Let's look at what your allegations of breach were in your complaint.
Yes.
You say that they breached the contract by failing to disclose that the house had latent defects.
Correct.
That caused the failure of the foundation, which had a material deleterious effect on the value of the house.
Correct.
Also that they breached it by falsely representing certain things that materially affected the value of the property.
Correct.
How do those two alleged breaches, how does the standard for deciding that breach differ from the jury instruction that was given based on Johnson?
Well, the point is there's a third ground I put in there, which is one that the jury never heard. And that was that they failed to accurately complete that report that they provided to my client. And that's the instruction that never went.
Being the seller's
Latent
disclosure and
disclosure
latent defect statement?
Correct. So that's my main issue, is that when but I'll tell you where that came from.
Well, but doesn't that then, as I read the disclosure and latent statement says, each seller is obligated to disclose all facts known to seller that materially and adversely affect the value of the property being sold. So why isn't that the same materiality
You have to
standard?
read it. Good. You have to read it. You have to read the entire thing. What does it say below? It says, and this is at the same part, this is the top, it says, the disclosure statement is designed to assist buyer in evaluating the property considered. Also, if you go further down, it says it's to be part of the contract. If you look at the disclosures themselves, for example, the questions are, do you know of any sliding, settling, earth movement, upheaval, or earth stability problems that have occurred on the property or in the immediate neighborhood? It doesn't say those that materially affect the value of the property.
Your position would be, if there was such a condition and it had no effect on the value of the property at all, it would still be a material breach of the contract.
Because my client, there was a no damage limit. My client is relying on this to argue that the seller's disclosure statement only related to those that materially affected the property, again, to go back to Burlington and Rockenbach, would mean this is just meaningless. You can just tear it up and throw it away because they already have a duty to disclose that.
If they fail to disclose something that has absolutely no effect on the value of the property, it's your position that that would nonetheless be a material breach for your breach contract count.
If my client chose to not close for that reason, keep in mind, my client had the opportunity, had the total discretion, obviously to act in good faith. But if there was something that was wrong, keep in mind, this is not a disclosure by experts. This is a disclosure by homeowners that's intended to help the home inspector. So there are questions like, did you see any erosion? Have you had any problems with retaining walls? And keep in mind, I had a next door neighbor, I had two neighbors who testified that they didn't say, I couldn't get it in the way I wanted to put it. They couldn't say they would have answered the seller's disclosure statement differently, but when I asked them the questions that were in the seller disclosure statement, did you see any problems with the retaining wall? 2 neighbors said yes, plus one of the neighbors, Tommy Addison, said that he talked to the seller, Mr. ADRAGNA, who said he was working on the retaining wall. Mr. ADRAGNA told him he was fixing the tile. So clearly they weren't telling the truth. In order for this seller's disclosure form to have, again, to go back to the analysis, in order not to give it an absurd result, you have to say it meant something more than just disclosing latent defects that had a material effect on the value of the property. Because then it's a meaningless form. Plus, keep in mind, it says it was to be used by my client's home inspector. He wasn't limited by defects that caused a material effect on the value of the property. So it would be of no value, no use whatsoever to a home inspector who's inspecting it for any defect, so that my client then, in the exercise of good faith, could terminate the contract if it was unacceptable to him. Also, this form, so again, I've told you we've had 2 neighbors that testified that they would have answered those questions differently. One of those neighbors, Tommy Addison, said he saw work going on out there, and he talked to the seller. The only way to reconcile the verdict that they didn't, well, I guess you could say they didn't believe the witnesses who had absolutely no stake in the outcome. I guess you could say that. But it seems to me the most logical conclusion is they said, well, yeah, there were cracks and the sellers knew about it, but it didn't materially affect the value of the property, right? Which then begs the question, how would the sellers know if it materially affected the value of the property or not? This is a form that's being completed by just a layperson, a homeowner. This isn't a form being completed by a structural engineer or someone who would know that. The purpose of this document, if you read it, in my understanding of contract law, that's how you read this document. It was to assist my client in conducting an inspection of this $1 million house that they only had 10 days to do it. I don't know if that explained it or not. I mean, does that make sense what I'm saying? Because it does, again, to say that the only thing this form did was just say what Florida law already said doesn't make any sense. Let me also point something else out to you. If you take a look at the contract itself, if you look on the top of paragraph 7 of it, the seller had already said, quote, seller represents that seller does not know of any facts that materially affect the value of the property, close quote. So if the seller has already represented on, this is Appendix 20, that they know of no facts, then what purpose is there to complete this extra document?
What did your client testify to as to the conditions that it didn't know about, that if it had known about it, it would not have closed on the contract?
Retaining wall failed and the huge crack.
And was there any debate that if their position was correct as to the condition of the retaining wall, the defects in the retaining wall, that was something that would have materially affected the property?
I'm sorry, would you? I guess I have to, yeah, obviously.
You seem to make an argument that says there could be things that would have prevented them from closing on the contract that didn't meet the standard of materially affecting the value of the property. But the things they were complaining about, if the jury believed them that those conditions existed, those were conditions that would have materially affected the property value.
Well, materiality is up to the jury to decide. We all know that.
Was there any defect your client was arguing was a material breach of the contract but didn't materially affect the value of the property?
Yeah, the fact that they didn't accurately disclose it. We had the home inspector come in and testify that if he had the answers to to the latent defect and disclosure form that the neighbors said how they would have answered it. That is to say, there were previous earth movement, there was previous problems, there was cracks, there was settlement, there was movements in that he would have disclosed all that in his home inspection report and would have said that needs to go to a structural engineer to analyze it. And if you look at the contract, it specifically says that that the contract is subject to a satisfactory structural engineering report.
Was
So
it
the-
his position that those conditions affected the value of the property?
Of whose condition?
The conditions that the structural engineer said should have been revealed?
Well, I mean, he's not qualified to talk,
Did
I mean, he's not
anybody-
qualified to talk about the value of the
Anybody
house.
testified that those alleged defects were such that they would materially affect the value of the property?
Those defects, well, obviously, the failed foundation did. That was the ultimate testimony that the foundation failed, and that was what substantially affected the value of the property. Our point is that the foundation failed while the house was being constructed. We introduced evidence that showed erosion during that, which is one of the questions on the latent disclosure form. We also introduced evidence that someone had altered the retaining wall during the course of construction. So I would have to say yes, that the testimony was a failed retaining wall would have material effect on the value of the property, because the retaining wall was only a few feet from the northern foundation of the house, so it really provided a lot of
So
structural
if
support.
that was an alleged defect, the jury instruction would have been adequate for that, right? Because
No,
Why not?
no, because what you're doing is you're imposing a greater burden on us. It isn't, they had a duty to complete that form accurately so that my client could conduct a meaningful examination. It wasn't their place to decide. Further, Mr. ADRAGNA testified during cross-examination that if there had been a defect and he had corrected it, right, that he wouldn't have disclosed it. That's what he said. That's not a fair answering those questions. Those questions are, have you ever had this? Have you ever had that? Have you ever had it? So he said that if he'd had the problem and he'd fixed it, then he wouldn't have disclosed it, even though that's a fair reading of the plain language of that disclosure statement. And again, you have to look at what was the purpose of the disclosure statement. It was to assist in the inspection of the house. The inspection of the house had no dollar limit to it. Now, if you were to say that my client could cancel it on an inspection that showed there was a material defect that affected the value of the house, then I would say, well, it would be of some use. But when I have someone who has the absolute discretion and good faith to cancel for any reason, one of the things I've argued with the judge or pleaded with the judge was, the judge said the only way you can breach a contract for the purchase of a house is if it materially affects the value of the house. And I'm going, well, if you don't close on time, that's breach of contract. If you can't clear title,
Well, I
that's breach
understand
of
those
contract.
arguments, but those weren't the kind of defects you were complaining about in this case.
No, but what I'm saying is the judge is imposing Johnson versus Davis onto a contract. The parties themselves agreed to the terms of the contract. If parties agree time is of the essence, then time is of the essence.
Counsel,
One day
you're down to 2 minutes if you want to
I'll
hold some
stop
time.
there. Thank you.
May it please the court. Your Honors, I am Michael Orr, and I represent the appellees, the ADRAGNAs. It's pronounced like lasagna. And
Is
they're asked,
Johnson v. Davis a tort standard, or is it a contract standard?
that's a question the Middle District has asked itself a few times, Your Honor, and most courts default and say it's a tort standard. It is a case that involved a breach of contract claim, a rescission count, and a claim for fraudulent misrepresentation. But regardless of what Johnson versus Davis stood for, the real issue that's being raised by this appeal, as Judge Palmer indicated in Your Honor's question to appellant, is whether or not that jury instruction was adequate. And the key language is on page 21 of the record on appeal before Your Honors. That is the seller's disclosure statement, the first page of that seller's disclosure statement, and it contains the language that Judge Palmer read, which is directly from Johnson versus Davis. And it starts out, in Florida, a seller is obligated to make known those defects that materially affect the value of the home. It actually says materially and adversely affect the value of the home. And then, leading in from that language, the next thing that is found in that document are the exact disclosures that the appellant is complaining about on appeal. The exact disclosures that they allege in paragraphs 35, 36, and 37 of their complaint, which can be found on page 7 of the record on appeal. The appellant, in its briefs, doesn't argue that the jury instruction didn't adequately cover 35 and 36, is what I'm hearing today, but that paragraph 37 that dealt with the appellant or appellees not accurately filling out the disclosure statement would be a breach of contract that the jury instruction didn't cover. There was no evidence that they didn't accurately fill out the disclosure statement other than the very evidence that was the central issue of the entire case, which was there a problem with the retaining wall and a defect or a latent defect in the foundation. That was the evidence that was put on by the plaintiff, and that was the evidence that the judge had to listen to when it fashioned its jury instruction, which it did properly. I'd also note, Your Honors, in reviewing the record on appeal for today, I could not find where the proffered jury instruction was actually filed with the court. I do know that at the beginning of this trial, the trial judge, Howard Maltz, had, pursuant to the 7th Judicial Circuit's standard trial order, asked for jury instructions from the plaintiff. And Your Honors will find the record in the supplemental record, pages 9 through 11, the discussion that Judge Maltz had with counsel for the appellant about the fact that he didn't comply with his trial order on proposed jury instructions. And still, late in the trial, he was still trying to get a jury instruction on this very issue that now they're complaining about on appeal. Even when they now complain on appeal that the jury instruction should be different, they don't tell this court in the briefs how the jury instruction should be different. They state that the jury instruction should have said that a breach of an essential fact, that's the word they use in their brief, should have been the instruction. Well, the only evidence that they tried to put forward before the jury was whether or not there was a problem with the retaining wall or issues, latent defects in the foundation. Clearly, as counsel has just conceded, those materially affect the value of the home. There's no dispute about that. So if the jury instruction would have read as suggested by appellant, the only result is it could have confused the jury. If it would have been read that way, the jury would have seen it the same way that they did with the jury instruction fashioned by the trial judge, because the only evidence, again, was the wall and the foundation. And for those reasons, Your Honors should uphold the jury's verdict by affirming the final judgment that was entered by Judge Maltz. As to the second issue that was raised by appellant in their brief, they're contending that an expert structural engineer, Nadeem Zabuni, testified and impermissibly was a conduit for hearsay evidence. I think this court's well aware of the two different rules, one saying that an expert can't be a conduit for hearsay evidence, and the other being under Florida Statute 90.704, that if it's the type of evidence that an expert relies upon in their profession, that they can, in fact, rely on hearsay evidence. On page 1239 of the trial transcript, that is where Nadeem Zabuni's testimony begins, and it lasts for 72 pages. This small amount of testimony that now they're challenging on appeal was a throwaway that the jury wasn't even concerned about, and we know that because Judge Maltz allowed the jury to ask questions of each witness. And at the end of this witness's testimony, the jury asked 5 questions, not one of which had to do with rain data. And this particular witness, Nadeem Zabuni, testified that the rain data did nothing more than confirm his prior opinion, which was consistent with the plaintiff's own engineer, Mark Keister, who testified on pages 85 and 86 of the record, of the trial transcript rather, that he believed the cause of the wall shifting was hydrostatic and hydrodynamic pressure. That would be the pressure from the wall, the water asserting its pressure on the wall, in addition to the load of the house and the pressure from the soil or the ground. Nadim Zabuni agreed with that exact opinion and stated the exact same thing, and to confirm or to evaluate his own opinion, he looked at the rain data from Tropical Storm Faye, which in 2008 dumped more rain in the area than any other storm previously. That is not the type of evidence, and by the way, it was never admitted as evidence to the jury. I use the word evidence. It's testimony that was given by Nadim Zabuni that resulted in some harmless or prejudicial error. And again, the jury didn't consider it. For those reasons, Your Honors should uphold the final judgment or affirm the final judgment as it relates to that expert testimony. And Judge Orfinger hit the nail on the head at the very beginning of this oral argument as it relates to that IRS brochure. It has absolutely nothing to do with the critical issue in this case, which was whether Joseph and Mary Lou ADRAGNA had any knowledge of a defect that materially affected the value of the home. And that particular brochure, once again, I could not find in the record on appeal where that was proffered and filed. It's unauthenticated. It's a brochure that nobody had testified about. It was not listed as a pretrial exhibit. If Counselor, in discussing this with Judge Maltz below, wanted to put forth the idea that they were flipping houses, he did that in his opening statement before the jury, suggesting they were flipping houses. So it was a theme he had already pushed throughout the entire trial. But if he wanted to, he could have asked for a jury instruction on the law, the Internal Revenue Code, and could have suggested a statute be fashioned as a jury instruction read to the jury. But he wanted to admit as evidence an unauthenticated brochure, and that, Your Honors, was impermissible, and the trial court properly excluded it. And in fact, they've cited no law in their brief to support the position that that brochure should have been admitted. Your Honors, I thank you for your time this morning, and I ask on behalf of the ADRAGNAs that you uphold the jury verdict and affirm the trial court's ruling.
Thank you, counsel.
Couple points. I want to beat this up on the income tax issue. I didn't move the brochure in. That was part of my proffer, so what it said. I just got to the point of asking them who did their income taxes. So let's be clear. I also want to make a point that the new Florida Supreme Court case on harmless error, Special versus West Boca Medical Center, 160-1251, dealt with excluding evidence on cross-examination. And what the court stated in this case at 1259 was the trial court erred by excluding testimony. The trial court had no discretion to exclude contested cross-examination unless you kept it out under 403, which was the prejudicial value exceeds the value of it. And that was strictly in response to that. But I do want to get back for a moment, if we want, on the, to get back to Johnson versus Davis again, because that is
How do
really,
you respond to the argument that you did not proffer the jury instruction that you wanted the jury to?
I beat the judge up so bad on it that he admitted on the record that I preserved error. Okay, I can rely on the judge saying that. That's in my brief. I say, Judge, I'm tired of doing it. I know I'm being, I think I called myself a horse's ass, but I could be wrong. And the judge goes, Mr. Griggs, you preserved error. Also, I believe that I did. It's in my
Did you proffer the jury, your proposed jury instructions?
I believe
And was there a pretrial order that you proffered the jury instructions you wanted to be used?
We did it during the trial under Rule 1.470, right, that was changed in 2010, I believe. It says jury instructions now are those that are on the Florida Supreme Court website, and that the court shall utilize that. Okay, so any case on the court's discretion on jury instructions preceding 2010 are suspect, because that's when the Florida Supreme Court rewrote the rule on that and said that the trial court shall use it. So yeah, we went through it together, what the standard jury instruction was, and I repeated to the judge, I want the standard jury instruction, standard jury instruction, standard jury instruction. So I don't,
counsel.
until finally the judge said, Mr. Griggs, you have preserved error.
Counsel,
That's
you've
what I
exhausted
said.
your time. Thank you so much.
Take care.
All right, we'll be adjourned for the morning. Thank you all so much.